Hello, I'm Matthew Davies. I am Head of Business Immigration at Wright Hassel, and I'm going to give a roundup of immigration law and developments since our last issue, with the political context as well. So, as we predicted, the debate has sharpened. The Illegal Migration Act has been passed by Parliament. It sustained 20 and more amendments by the House of Lords. There's a great deal of disquiet. There's dismay from human rights groups because of assumed incompatibility with some of the UK's obligations under international law, the 1951 and 1967 refugee conventions. There are questionable definitions for safe countries. There are removals, arguably, of modern slavery protections in the asylum arena, and extended powers of detention and reduced appeal options, further reduced appeal options. And against that background, the Court of Appeal has rejected by a majority the lawfulness of the flagship Rwanda policy as contrary to Article 3 of the European Convention on Human Rights. That's based on the risk of mistreatment, although the government is confident of overturning this at the Supreme Court. And government figures lay bare the sheer extent of net migration and loss of control since Brexit. Home Office statistics show record annual net migration of 606,000, and that's coincided with a highly critical National Audit Office report on the asylum system. We've got the still fresh memory of 2019's taking back control of our borders rhetoric, a manifesto pledge, of course, as well, and that collides with 2023's reality, which is a surge in dangerous illegal small boat crossings, a lengthening asylum backlog, and a stretched public purse, which is blocking much-needed investment in the immigration system. One commentator's pointed out that the system's overwhelmed, not so much by new arrivals as internal mismanagement, and the taxpayer is picking up the cost of housing migrants who are barred from work, unable to contribute economically, and are in that position for years rather than weeks because their applications are taking so very long. In a properly funded and managed system, the thinking goes, they could be decided far more quickly. And at the end of the current process, few of those applicants whose claims fail are actually removed from the UK anyway. And against that, we've got opposition claims that the UK's low-wage economy has actually caused this loss of control, and they're starting to stick. A Social Market Foundation report in June concludes that immigration policy is fueling rather than alleviating skills shortages, for example. There's an over-reliance on subsidised overseas labour to fill skills shortages, they say, and that's just the start of it. The opposition leader proposes to fix the apprenticeship levy, fill the skills gap and stop businesses from recruiting from abroad if they don't pay properly. Employers would no longer be allowed under their plans to pay overseas workers 20% less than the equivalent domestic wage for shortage occupations. But would that actually make a difference in practice? Not so clear, perhaps. The labour market remains relatively tight, and in that context, skilled and unskilled migration just keep on rising. There's nothing very new here, but in a series of reactive moves, the government sought to dampen the criticism it's getting. The effects of what it's doing are limited on the whole, but here's a quick roundup of them. The temporary seasonal worker route is being promoted this summer for seasonal horticultural work or poultry production work, and a person on the seasonal worker route can stay for a maximum period of 6 months in any 12-month period. There's no long-term entitlement following that. And that's obviously of some help to a very hard-hit sector following the loss of pre-Brexit free movement. But there's an overall quota. Only endorsed scheme operators approved by DEFRA and licensed to operate with seasonal visas can actually use it. It's worth saying it's popular with displaced Ukrainian nationals. It's a source of work for them, but there may be better sources of work too. On investor visas, the Supreme Court upheld the government's appeal in the case of Wang against an earlier finding. They ruled that participants in the now closed investor programme can't rely on a funding scheme whereby they borrowed money supposedly under their ownership and control to meet the high qualifying threshold. That left no guarantee that the money stayed in the UK economy, of course. Now, again, the effects of this are going to be limited because the investor room was closed in 22 amid alarm at its use by wealthy Russians. Nevertheless, it's something that the government has pointed to as they're closing a loophole. The Migration Advisory Committee is due to report to government again on possible revisions and additions to the shortage occupation list, giving priority and concessions to skilled migrants, in particular high-demand fields. There's been a shock hike in the immigration health surcharge, by which sponsored employee migrants and others pay an annual fee to use the NHS. That tops out at over £1,000 a year, up by a third, really, for many applicants. And that's combined with an approximate 15% increase we see coming in immigration filing fees, also announced last week. The implementation dates are awaited, but they would be far off. Public sector pay rises have to be paid for, so goes the thinking, and this implies an electorally palatable path to raising government revenue. It's going to put off sponsors and potential relocating skilled workers, though. There's a planned crackdown on illegal working. The employment of workers who don't have the required immigration permission to do the jobs they're doing has culminated in 105 arrests so far. Over 300 immigration officers were deployed in illegal working raids. Commercial premises, including restaurants, car washes, nail bars, barbershops and convenience stores were at the top of the list there. Nothing new, but the Home Office has also signalled repeatedly that it's going to extend its investigations into professional services businesses, and that there's significant new resource dedicated now to tackling illegal working. It's a good time, let's say, for businesses to review their right to work checks. Access to the Ukraine extension scheme has been extended again to May 2024 for displaced Ukrainian nationals. That's generally going to be politically more popular than not. And other measures include curbing the ability of international students to switch into work routes prior to their course completion. The government claims here that it's closing a loophole by which some students are using the route as a foothold when their intention is not so much to complete their courses, but to enter the resident labour market by an easier route. Switching from student to dependent of a person in a work route being blocked as well. Now, there's post-Brexit trade agreements, which have got some positive impact as far as those needing to rely on the immigration system are concerned. There's some relaxations for some countries in relation to visit activities and processes. The India-specific scheme for young professionals, for example. There's the inclusion of mutual immigration programs and priority routes as part of trade discussions. That's an ongoing thing. So far, there's not a great deal, but we think there will be more. And there are proposed relaxations for migration for elite footballers as well. That's not many people, but there's a lot of money riding on that in the UK's big money sport. So government ministers actually, some of them are beginning to question the effectiveness of current policy. The debate goes on. It's been going on for 2 decades and more. And it's worth asking the question, has any policy, any immigration policy, been truly effective under any government in recent decades? We'll see how things play out, but I think it's hard to argue that things are working as they should be right now.